Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call held every 2 weeks on Thursdays. Today is July 25th, 2019. As you would have heard when you logged in, this call does not create an attorney-client relationship. I did not see anything that I could consider to be a frequently asked question today. I will go over the questions in the order presented. And as I am going over them, I will ask if you have a follow-up question on them, and I'll try to answer to the best of my ability. The first question is about humanitarian reinstatement of a case where, let me just make sure you guys can hear me 1 second.
The conference is now in conversation mode.
Can you folks hear me okay, guys? Can you all hear me?
Yes.
Okay, thank you.
Yes.
Thank you.
The conference is now in presentation mode.
Okay, so the first question was about whether there can be humanitarian reinstatement where the principal petitioner passes on, dies, and somebody else can step in to continue the case. I don't know the answer off the top of my head. I do know that there are some kinds of humanitarian reinstatements which require that the beneficiary must be in the United States. They don't apply to people who are not in the United States. But I'm not sure exactly how this one works. I don't remember off the top of my head. So I will not give you an answer and mislead you. I would just say, please take a look at the USCIS website. It is fairly informative. You should be able to figure it out. And if you cannot, I would advise you to consult with a lawyer. You can consult with our office as well. We can look at the law and let you know specifically whether or not there is anything in the law that prevents your case from being terminated, from getting terminated. Okay. I don't have a whole lot to add to this, but if you have a follow-up question, press *5. You can press *5 on your phone. I don't have a whole lot to add to this, but still if you need to, okay. So that comment is not necessary. Next question is from HAB about the combination of EAD and H1B statuses. Folks, normally, even when you have an EAD and a 485, I always tell companies as well as employees to keep their H1B active. There are so many ways these days government can come at your 485. For instance, if you have anything in your background where, let's say, you worked without authorization, government can try to make an issue of it. So there are so many ways. For instance, I had a case in which I normally don't go for interviews for adjustment of status unless there is something very tricky involved. It's not worth paying an attorney to go for a adjustment of interview normally. Nowadays, I'm not so sure I can say that with complete confidence. We have to look at people's backgrounds. So I had a case in which not green card, but naturalization was denied. Imagine that. 5 years, 6 years, 7 years it took you to get a green card. And then 5 years after that, you apply for naturalization. The government came at this guy saying that one of your old employers was convicted for fraud, etc. And this gentleman had nothing to do with it. So they tried to deny his naturalization. They did deny it actually. I was more concerned about them going after the green card. So they can do all that. By the way, that case did get resolved, no problem at all. So they can go back in your background and try to attack your green card application. That's why it's always better to have an H1B application also active, an H1B petition also active simultaneously. Now, if you were about 3 months from your green card, maybe I could skip the H1. Although, given a choice, I would rather have them both active. So the confusion here was, should I continue to renew my H1B while I wait for dates to be current? The answer is yes. If my 45 is denied when my date eventually becomes current, will I be able to continue working on renewed H1B? And the answer is yes. So even if your date becomes current once an H1B has been approved, you are entitled to continue working on it. I don't see any problem with that. Next question is, won't my H1B also be invalid since the basis of my H1B extension is gone? So no. Once they have given you, I have looked at this actually from another perspective very carefully. I think the government does have the power, arguably, to try to revoke a case when the basis for the extension are gone, such as denial of the green card process. So the 1-year rule and the 3-year rule are all gone. But I don't think it's that simple. I think government is well advised, and they normally don't even think about it, to try not to revoke your H1B that has already been granted. My extremely strong argument for that position is this. On the date you filed the H1B, you were entitled to it. If later on the reasons or the technical reasons that form the foundation of your approval go away, government should not be able to take away your H1. I don't think they can. But theoretically, at least the possibility exists. So all in all, renew your H1B. I always advise that. Press *5 on your phone if you have a follow-up question. Press *5. Okay. Next question is from Rajiv. I-140 approved with company A. I want to transfer to B, but I want to process green card through C. Is that okay? Absolutely. Is it okay to process my green card with company C without doing it with company B? Yeah, you're not required to file a green card through every company you work for. And it is also okay to file a green card through a future employer as long as you do intend to join them upon approval or before approval of the green card. Another way of this question is, will I be able to apply for H1 transfer at company C with I-140 approval of company A? There is not a single doubt about that. You can. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next question. Priyanka says, I'm currently on H1B Cap exempt and I've been picked up for Cap Subject H1B. Can I transfer my Cap Subject before October 1st? Cap Subject is approved. So the answer is, I am not so sure how that would play out. I'll tell you what the problem is. I've heard the government say in various meetings, etc., that if your H1B is revoked or withdrawn by the old employer before October 1st, then you are still subject to the cap. So first of all, you must get either a change of status or a visa stamping. On top of that, if your H1B is revoked before October 1st, you are back waiting in the queue. So difficult to say. I think the smart thing to do is to wait until after October 1st. *5 if you have a follow-up question on this. Press *5 on your phone. Okay. Next question. Came to India, attended an H1B interview, got a 221G, and now it has been sent to USCIS for review and revocation possibly. I'm still working from home with my employer. How long does USCIS takes to take a decision on my petition? It can be several months. That's as close I can get, as close as I can get to the to a guess. Several months. Don't know how many months. but it could take a while. Can I do anything like file a petition again or any other way? Yes. One way to do that is to file another H1B premium processing. Make mention in that the old case was sent back to the USCIS and see how that plays out. There certainly is no harm in trying that. *5 if you have a follow-up question on this. *5. Okay. Next question is from Amin 163. I have an approved I-140 from employer A with July 2016 date. I've got 6 years of H1 till November 2021. Current employer has not yet filed for green card. In case HR 1044 is passed and the dates become current, well, first of all, I don't think you can depend upon that, because I would be very surprised if any provisions, any laws are passed in this Congress. The House has a very different view than the Senate, and then nobody knows what Trump is thinking anyway. I don't think Trump knows what Trump is thinking. So therefore, it is very difficult to predict how these laws will play out. But let's go on with your hypothetical. Can they port my date? And the answer is sure, because porting is a part of the regulations. They can't just take it away without some kind of a notice. So you should be okay. On my I-140 from previous employer, A says AOS needs to be filed once dates become current. Will I miss the boat and I'll have to file new green card with employer B? Okay, so porting should certainly be possible. Now the question is, on my I-140, will I miss the boat and have to file new green card with employer B? I'm not sure I understand your question. I know that you have an I-140 approval from the old employer. So that gives you the priority date. But that does not give you a green card. So in order to use that priority date, you have two choices. Either you can go back and get a job offer / employment with the old employer, which has its own issues. And you can listen to some of our older conversations, frequently asked questions, where I've discussed this issue in detail. When you have received part of the green card approvals, like I-140, from one employer, then you leave and join another employer, and then you want to go back to the old employer, government can question what is your real intention. But normally, it's okay. So you can talk with your lawyers about that. So if the old employer were willing to take you back on the job they had offered under the green card, and you were willing to go back, they can help you file a 485. Not sure what your question is, a little unclear. If you're here, press *5 on your phone. Okay, you're not here. So, not sure I understand the question, but filing through the old employer requires their and your intention to give the job and join the job sometime in the future. It can be even after you get the green card. In order to use the priority date, you do have to start the green card through the new employer, because even though the date is yours forever, it has to be put into a green card. By itself, it doesn't mean anything. Any follow-up questions, please press *5 on your phone. Okay, let's go to question number 8. VK says you addressed a similar issue a month ago where somebody has an EB2 NIW approved, and then they get an EB1 approved. Can they transfer the priority date? And the answer is of course. So now the question is, I've got my EB1, but my date shows as the newer date. It doesn't reflect the NIW approval petition's date. So whenever the NIW was filed, once it is approved, I'm entitled to the priority date, which is the filing date of the NIW. What is the best way to contact USCIS to get the priority date changed? They often do not change it on the approval notice itself, often. But the best way is, like everything else, just create a service request. So call their customer service number and create a request. In the event I can't get 797 corrected while filing Form I-485, which receipt number should I use? I won't go into filling out forms with you. That's a little out of the way for us, and maybe legal malpractice also. So suffice it to say that we often run into these kinds of situations, and we usually put in a cover letter explaining the situation, and we put in the approval notices, for example, in your case, both the national interest waiver as well as the EB1. *5 if you have a follow-up question on this, press *5. Okay. Question number 9. You had earlier advised me to wait till after my wife's naturalization before I attend my N400, because earlier you had traveled on an expired advance parole. So the N400 is now approved. Since you were stopped at the airport when you came back on your advance parole, I think you have to say yes, you were detained by an immigration officer. During the interview, why did you miss interview previously? They never asked that question. And if they ask that question, you can let them know upon advice of counsel. Although, like I said, they never asked that question. *5 if you have a follow-up question on this, press *5. Okay. Question number 10. I started with at client A's location on H1B visa, filed an amendment for the client location, got an RFE. There was a site visit to the client's location. Since then, there's been no concrete update regarding the processing. Okay, so I'm assuming you're saying the amendment is still pending. Okay, but I would like to travel. Look, I don't know the details, the weaknesses and the strengths of your case. You should talk to your lawyers, but it's perfectly legal if somebody already has a visa stamp on their passport and the visa stamp is still valid when they come back, to travel out of the USA even when the H1B amendment is pending. You could travel, and I don't see, so your case is not premium processed. You should premium your amendment. That I think would be a good idea also. *5 if you have a follow-up question on this, *5. Okay. So the next question from Danny, I'm a little fuzzy on the details because I don't remember exactly how this works, but read the instructions on Form N as in Nancy 600. Read the instructions on the Form N600. That gives you in a nutshell which kind of children are entitled to derivative naturalization. Okay. Although I have nothing else to add to this, you can, if you want, ask a follow-up question. I can try to answer it. *5 if you have a follow-up question. Press *5 on your phone. Okay. Let's see. This one is from India. Okay, India, go ahead, please.
Yes, please. This is regarding the question which I posed, which you just asked me to do a follow-up question. I just want to clarify. We were naturalized in the U.S., but due to family reasons, we are staying outside. Right. So now we have applied for a 130, and it's been approved.
Right.
Now we'll be traveling back and moving back to the U.S. So basically what I've been reading is under the new sections that she becomes a citizen on entry on a long-term visa, on a permanent residency visa.
Right. So my answer to you is that I
Right.
don't know how this process works off the top of my head. I have to look at the law. And the form that normally people use to understand naturalization is typically N600. So many times N600 can be optional because citizenship is acquired automatically by some children. Nevertheless, if you need the proof of citizenship, you have to file N600. So N600 is not so much to adjudicate the case as it is to get the proof of naturalization.
I see. A quick question, sir. Because looking at this secondary, it says it's the DS5507. Here the statement says that I have been physically present or have had a residence in the United States as follows. Just the clarification I'm requiring on that. Does that mean that I have not abandoned my residence in the United States? Is that what they want to find out?
I hesitate to comment out of context, sir, because I don't know exactly what the context of this is. Residence can be something very simple. No. Residence can be something very simple, but there are so many shades to residence. One shade is something called domicile. Domicile means that not only are you physically present in a location, but you have no intention to leave that location. That is what establishes a domicile. Non-abandonment of residence requires certain other factors. So I don't know really there are, like I said, 3 or 4 different shades to residence. So I don't know the context. I have to look at the form. I wouldn't be able to answer that question, and we can never help you fill forms. That's unethical, maybe even legal malpractice. Because every form says if somebody has helped you prepare the form, they should sign the form.
Sign the form correctly. One more question, because this is respect to dates, not to fill the form.
When I naturalized, I obviously given them the dates of my physical presence and my travel in the U.S. But that's been almost 15 years since now. I have no clue what those dates are. And my passports are expired and I don't have them with me any longer. So now if I would put the dates down, is there any chance I can ask the USCIS for those dates? Would they have the copy of the dates?
What are these dates?
Because I have no clue what the dates are.
What are these dates again?
Because when you apply...
for
naturalization, right? When you apply for naturalization, they ask you from when to when you've been in the country, when to when you've been outside the country. And this is in the time period of 2002 to 2007.
Yeah, no, they shouldn't be asking you. They shouldn't be asking you. I don't see how that is relevant to anything anymore. You are naturalized.
No, sir. Right. Whereas when I'm filling out these forms for my daughter, they're saying I'm the biological parent, and hence they're asking for dates of my residence. So I don't remember the dates, so how can I fill in the dates? Is my question there.
You can certainly, I don't know, because again, this is a contextual question, but it is not possible for you to recreate those dates except through your own sources. I doubt very much that USCIS has any record of your arrivals and departures. I think what you can do is to guess it and put a cover letter saying these are our guesses. We don't know for sure.
Fair enough. Thank you, sir.
You're welcome.
Thank you so much.
Good luck. Okay, so next one, question number 12 is about an L1A. And I-140 has been approved, date of September 2017. We filed 485, traveled out of USA in January, returned in March of 2019. Fingerprint review was done, completed in Jan 2019. Wife was called in, both went for fingerprints. She's got her approval, but my GC EAD AP shows case is received. Is this common where dependent receives the EAD AP before the primary? Yeah, it can happen. USCIS has a lot of blips that go over and below what is considered to be normal. So it's difficult, really difficult to predict or to state definitively what is normal and what is not. This can happen. Do the cases get approved separately? Yes, they do. *5 if you have a follow-up question on this. *5. Okay. Question number 13. I'm currently an employee full-time of H1B company A. They have a parent company B. Most employees in my company A are going to be terminated. My supervisor and few employees are moving to company B. Supervisor is willing to keep me employed for 2 more months in company A, then terminate my position. Would it be legal for me on H1B to be the only employee in company A? I don't see why not. There's no requirement for a certain number of employees. I would definitely want you to discuss this with your lawyers because I'm not familiar with the whole thing. Ask them to check whether the parent company can qualify as a successor in interest. That can make things a lot easier. But as far as your question is concerned, can I work for a single employee company? Sure. *5 if you have a follow-up question. *5. Okay. Question number 14. Swapnil says, I have my green card process started. I-140 done for my current company at location A. They are moving to location B. Company is saying that I need to restart the process. Well, first of all, we would need to know how far are they from each other. So if location A and B are more than 40, 50, 60 miles apart, then you might have to start the green card all over again. Frankly, I would not like to comment on this definitively without looking at the entire paperwork. But if you have competent counsel, you can discuss it with them. It may not be necessary if it is just within a few miles. You don't have to start the green card all over again. You're fine. *5 if you have a follow-up question on this. *5. Okay. Question number, there is a follow-up question. All right, let's see. This is from Oklahoma. Yes, Oklahoma, go ahead, please.
Yes. So both the company is still the same. The company is not changed, but the location is with the different states. So
How many miles?
from one state to another
How
state.
many miles?
It's let's see, 700, 800 miles.
Oh yeah. So chances are you are going to have to start all over again. But the good news is that your I-140 is already done. You will keep that priority date. Okay.
Okay.
Anything else?
Okay. Okay, that's all. Thank you, sir.
Good luck, sir. Okay. So then the next question, number 15, is 2 separate employers filed for me going from F1 to H1 in the lottery. One of the petitions is already approved with the change of status. Should the other petition be approved as well? Or do I have to need to leave USA to resolve what employer I'll be working for? No. Typically, the way it should work is if the second case also gets approved, you have your choice with whom you want to work. Okay? Approval of one H1B does not overrule approval of an earlier approved H1B. They can both coexist. And you can decide which one you want to join. Since my change of status has already been approved with the first case, is it possible from my second petition? Yeah, it's one of those areas of law that nobody really thought about that deeply. As a normal rule, they don't really worry that much about it. They should be able to give you a change of status for the second case as well. But hard to say. Question number, *5 if you have a follow-up question on this. Press *5. All right. This looks like the last question for the day. My spouse worked on H4 EAD after expiration for 5 months, assuming it's an automatic extension. Well, you cannot do that. So that means there was a violation of status for 5 months. Easiest way to correct this is to leave the United States and re-enter using an H4 visa. Now you are back to H4. The sin of being out of status would now be expiated. It would be gone. So that is the best solution. *5 if you have a follow-up question on this. Press *5. Okay. We have one question. Let's see, where is it from? Texas. Texas, go ahead, please.
Yeah, thank you so much for taking my call. I wanted to understand, like, how much trouble we are in.
Oh, no, it's not a trouble. It's not a big trouble. It's just inconvenience. Because under the law, by continuing to work, you did unauthorized employment. That means they're not going to give you status within USA if they find out about this. So it's easier to just go outside USA, get H4 visa stamping done, and come back. Once you're back, the old sins are washed away. But don't think you don't have to reveal them. If there is ever a question in any form, including DS 160 that says, have you ever violated the terms of your visa? You'll say yes, and you'll explain how. That by itself is not a ground for denial of an H4 visa or an H1 visa or a green card. Okay?
So it would not be held against us if we say yes every time.
You have to, and it won't be, it has no legal consequences. But if you lie about it, it can have legal consequences. Okay?
I see.
So I wouldn't worry about it. This is not going to be an issue for you.
Okay. Thank you so much.
You're welcome. Good luck. Okay, folks, I have about 10-15 minutes before I have to go into another call. So any questions? Anyone has any question, press *5. Anyone has any question? Wow. We have a silent audience today. Okay, very good. That was quick. We were able to go through 16 questions in just 30 minutes. Thank you everyone for being here. I'll see you again in 2 weeks. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.